Hello, everybody. Good afternoon, and welcome to the American Constitution Society's annual Supreme Court Review. We have a really phenomenal lineup for you today, so I'm looking forward to a very stimulating discussion. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. I think probably this audience knows who we are, but just to make sure, we were founded in 2001. We are a national network of lawyers, law students, law professors, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues, such as the ones we'll discuss here today. There was much at stake in the Supreme Court's October 2011 term. On the court's docket were questions about whether the government can place a GPS tracking device on a suspect's car without first obtaining a warrant, the scope of Title VII's ministerial exception for religious institutions, and whether the FCC's rules regarding pleading expletives are unconstitutionally vague. But certainly among the most awaited decisions are those resolving the challenges to the Affordable Care Act in Arizona's SB 1070. Our panelists today will review the October 2011 term and highlight for you the important cases and trends. They will also look ahead to next term, when the court will consider the constitutionality of the University of Texas's admissions program, and possibly challenges to California's Proposition 8 and to the Federal Defense of Marriage Act. To get us started, let me introduce our moderator, someone who no doubt is already well known in this room. Tom Goldstein has argued 25 cases before the Supreme Court and, in addition to practicing law, teaches Supreme Court litigation at both Stanford and Harvard law schools. Tom founded and is the publisher of SCOTUS blog, which in 2010 became the only weblog ever to receive the American Bar Association's Silver Gavel Award for fostering the American public's understanding of law and the legal system. In 2010, the National Law Journal named him one of the 40 most influential lawyers of the decade, and Legal Times named him one of the 90 greatest Washington lawyers of the last 30 years, and praised him for transforming the practice of law before the Supreme Court. Who better to navigate the term for us? So please join me in welcoming Tom Goldstein.
Thanks so much, Caroline. Thank you to ACS for putting together this program. Thank you to all of you for taking time out of your day to come and talk with us about the Supreme Court term. Obviously, there are things still to come, but hopefully we can fill in a lot of the gaps about both what the court has decided and what it is going to decide in a term that is so fraught with important constitutional questions. The current Supreme Court term may put to the test the notion, like few things do, that in progressive legal thinking we are celebrating 10 years of progress. But that was a joke. But it is undeniably an incredibly important term, and we look forward to a lot of important cases next term as well. This is going to be a program in 4 parts. We're going to talk about the major decisions of the term, with the exception of healthcare to start, then turn to healthcare, then turn to the cases that either have been granted for next term, of which there are relatively few, but several really big ones on the horizon, and then finally we're going to do questions. We're going to get to questions right at about 2 o'clock and do that for about 20 minutes, so we may go slightly over for that reason. We want to make sure that you are part of the conversation as well. My principal job is to not talk about the substance of law, but to hold up these PDFs, which are both yellow and then red, thank you, because we have so much to talk about and so many incredible speakers that it'll be really hard to cover all of the ground. So my principal responsibility is, in a sense, to be mean and to encourage everyone to stick to the relatively short amount of time we have to cover a lot of these different cases. So I, in advance, ask for forgiveness from the panelists when I do that. Walter Dellinger, will you start us out? Walter Dellinger is a partner, of course, at O'Melveny & Myers, the former head of the Office of Legal Counsel, the former acting Solicitor General of the United States, teaches at Harvard Law School, and for many years taught at Duke, but he is on leave. Will you start us out with the incredibly important GPS case?
Well, this was a case decided early, but of great importance. The FBI surreptitiously attached a GPS tracking device to the underside of Antoine Jones' car, or actually to a car registered in the name of Antoine Jones' wife. For the following 4 weeks, that GPS device calculated and transmitted by satellite to FBI computers every movement and identified every stop Jones made in his vehicle every 10 seconds, 24 hours a day for a month. Over the course of that month, a virtually seamless GPS surveillance, the government obtained satellite-generated data not just about his discrete journeys, but information from which they could extract the patterns of his living, the kind of information from which you could identify people's political or religious affiliations or intimate associations. Because the warrant was conceitedly invalid, the government defended the introduction of 2,000 pages of data that was generated by this GPS tracking device on the grounds that this was not a search within the meaning of the 14th Amendment. Because a search has to invade a person's reasonable expectation of privacy. The government's position was based on precedent which said quite clearly and emphatically that there is no reasonable expectation of privacy about your movements on a public thoroughfare, a statement that the government had made in the context of a beeper placed inside a container that allowed you to follow closely a particular car. So that was the hurdle in this case. One thing that was different was that in no case had a person's own property been used as part of the basis for tracking, as it was here. So in addition to arguing that there was a reasonable expectation of privacy on a public thoroughfare, that the government wasn't going to be using 12 military-installed satellites to track your every movement, something your neighbor could not do. But we also argued that there was a property violation, hoping that the more property-oriented justices would find that appealing, and indeed 5 justices did, in an opinion by Justice Scalia, that the right to be secure in one's persons, places, houses, and effects included an effect such as a vehicle, and that the intrusion into property was indeed a search. 4 justices joined that opinion, so 5 were on that. And then Justice Alito, for the more liberal members of the court, rejected the notion that property rights was either necessary or sufficient, and said you should look at the reasonable expectation of privacy, and in this case, the length of the surveillance invaded the reasonable expectation of privacy. So all 9 justices found this to be a search. Tom Goldstein raised the question of whether the court might still hold that one need not have a warrant, because the court didn't need to reach that. The government had taken the position that if it was a search, of course a warrant was needed. They didn't appeal on that basis. I disagreed strongly with Tom, but I think, this is a great tribute to you, Tom, the United States government has now taken the position of the Ninth Circuit that even though it's a search, they don't need to obtain a warrant. I don't know what they cite for that other than blog of Thomas Goldstein, but apparently these days that's enough to influence the litigating position of the United States. Let me conclude by saying that what's really important about the Jones case, since issues are left open to the future, is what they didn't do. Had they affirmed the conviction, it would have meant that any law enforcement officer, federal, state, or local, could, for any reason or no reason at all, install a GPS device on anyone's car, because there would be no reasonable expectation of privacy, no search, no Fourth Amendment. And the morning of the argument, it was argued, we did the briefing, but it was argued by Steve LaCar, who had been trial counsel for Antoine Jones, so I felt a little more comfortable saying on NPR the morning of the argument that under the government's position, any law enforcement officer in the greater DC area could place a GPS device under the cars of all of the justices just to find out what they did when they left work. And that was the first question the Chief Justice asked counsel. Is it your position that they, and he had not listened to NPR, so he said, you mean Justices of this court? Yes, this court, said the Chief Justice. A further answer, the Chief Justice says, I take that to be a yes. At that point, I think the case was effectively decided, and that road were closed for the future.
What does it tell us, Walter, then, about other technologies, cell phone tracking, other things that in the future, beyond GPS devices, that you don't have to physically attach them?
Right. The great issue comes down to this. Under the Scalia opinion, devices that do not require physical attachment, accessing your cell phone, other ways of monitoring your vehicle that might occur without a physical attachment, would not involve the seizure of your property, and therefore would not be covered by this. This is a search opinion of the Chief. They would be covered, I think, by the opinion of Justice Alito, also for fives, and Sotomayor joined both camps. But in that case, Alito certainly acknowledges that a surveillance of a, quote, short duration, you would not need a warrant, would not be considered a search. The non-transitory searches of longer duration would. He says, we know it's an inexact line, but if law enforcement is worried about that inexact line, just err on the side of caution, get a warrant.
Terrific. Paul.
Thank you, Tom.
Well, I haven't introduced you.
Oh.
Don't. Tons of time. Paul Wilson is a partner at Wilmer Hale, a former assistant to the Solicitor General, has argued 20-some cases at the Supreme Court. Has two major topics for us, the religion and Hosanna Tabor, and yesterday's brand new Williams confrontation case.
Right, yesterday's decision in Williams, which one commentator already referred to as a bloody mess. So we'll be talking about that. I'm going to start with the Hosanna Tabor case. This is a case involving the reach of the anti-discrimination laws to employees of religiously affiliated organizations, and what has been referred to as the ministerial exception, somewhat poorly worded name, but the ministerial exception to those anti-discrimination laws. Cheryl Parrish was a teacher at a secondary school, a religiously affiliated secondary school, the Hosanna Tabor School. She went out on disability leave, and when she wanted to return from her disability leave, the school said to her, well, we're sorry, but we filled your place, and you can't come back, but we'd be happy to negotiate a kind of a long-term exit for you and keep you on benefits for a while. She threatened to take the case to the EEOC, whereupon they said, okay, now you're really done, and your position with your calling with us is completely terminated now. She proceeded to involve the EEOC, which actually sued the Hosanna Tabor School, alleging that they had dismissed her unlawfully, not on the basis of her being disabled, but on the basis of unlawfully retaliating against her for having opposed her allegedly discriminatory treatment on the basis of her disability. So this is a classic case of retaliatory treatment that is being challenged in the court as illegal under one of the anti-discrimination laws. One of the interesting things is the anti-discrimination laws, the employment discrimination laws, almost all of them contain exceptions allowing religiously affiliated organizations, narrowly defined to really mean like churches, not more broadly than that, not universities, but really narrowly defined. It allows them to give a preference to or to limit their hiring to persons of particular religious persuasions, but there is no kind of broad exception for treatment on the basis of sex, race, age, disability. So if you read these laws very strictly, you would conclude that, in fact, the Catholic Church might have to have priests who are women, because there is no statutory exception that would allow them to decide otherwise. Well, I can tell you, there is not a single justice on the Supreme Court now, or ever has been, who would conclude that the Constitution would allow the government to force the Catholic Church or any church or any religious organization to decide who is going to be their minister or their religious officiant on the basis of notwithstanding sex or race or age discrimination. This case, though, pushed that principle out, I think, a bit farther for several reasons. First of all, it involved a claim of retaliation, which I think raised some broader principles, because there are many, many laws that prohibit employers from retaliating against their employees on things that are not really connected to anti-discrimination principles. For example, you can't retaliate against somebody for contacting the police and reporting a crime. Many of those situations. Secondly, this involved a religiously affiliated school and not a church, not a religious organization. And third, there was considerable debate as to what Ms. Parrich's role was in the sort of the propagation of the religious doctrine of the school. That is, she, like many teachers at religiously affiliated schools, had duties that could be fairly called secular and also had duties that could be fairly called religious. She taught both secular subjects and religious subjects. She escorted the students to religious devotion on a regular basis. And she herself had gone through a course of religious training and had received what her church referred to as a call, which gave her a religious status, not the same as every other teacher in the school. So, whereas I think there's absolutely no question that the Supreme Court would have said that there is a constitutionally required exception to the anti-discrimination laws for ministers of a church, there were a lot of questions, I think, about how far that exception pushes out. And in this case, even though there were all three of the points that I just mentioned that left it somewhat open to doubt as to how far that exception would reach, the Supreme Court unanimously concluded that the Constitution prohibited the application of the anti-retaliation law to the school's treatment of Ms. Parrich. The most interesting thing to me about the case, there are two interesting things. The most interesting thing to me about the case, to me the really hard question is, who is a minister under this exception? Because many religious traditions don't really have someone who is called a minister. Ordination is not really even a concept in many religious organizations, many religious traditions, and indeed it is in some cases the entire laity is considered to be the ministry. The entire congregation of the faith is the ministry. And Justice Alito and Justice Kagan wrote a very interesting concurring opinion drawing attention to this point. The other interesting point to me is there was virtually no discussion at the court about the fact that this was a religious school as opposed to a religious organization like the Catholic Church. And so I would suspect that this decision will play a role in the upcoming litigation brought by religiously affiliated organizations challenging the contraception requirement of the essential benefits provision of the healthcare law, assuming that there's anything left in the healthcare law, of course, because that the government had tried to draw a line between what I will simplify and say churches and what I will call sort of church-affiliated schools, which the court saw, which nobody thought would be of slightest significance. I want to turn very briefly to the Williams case, which was decided yesterday. This is a case that is the latest in a series of cases that the court has been deciding entirely by 5-4 votes over the scope of the confrontation clause, which allows a criminal defendant to confront the witnesses against him. And so the question in these cases has been, what if the witness against the person is not the live witness there, but essentially a statement that is being introduced through a live witness? So this could be, it has been in such, hearsay statements such as statements to 911 operators. In recent years, the crucial things have been laboratory tests. That is, suppose a live witness opines about or testifies about or introduces a laboratory test that establishes somebody's DNA or establishes that a drug is crack and not cocaine or something like that. Do all of the people who conducted the laboratory tests have to be brought in to testify, or can the government essentially rely on somebody who is summarizing the results of those tests and testifying to that? And the court has been quite sharply divided on all of these cases, which have been sort of going about the last 6 or 7 years, 5-4, in decisions that have not followed by any means the usual ideological grounds. The case in Williams was can the government introduce an expert who will testify that there is a DNA match between two samples, one which was drawn from the criminal defendant and one which was sort of in the government's storage weight. This is a rape prosecution, and they had taken DNA samples to try to identify the suspect should he ever be caught, which he was. And the court split in really a 4-1-4, which is very difficult to summarize in a short way. But essentially, the pro-government, the pro-prosecution position prevailed, but on two completely different theories. For adopting the view that this is sort of not really the expert isn't really testifying to the truth of the matter, and Justice Thomas adopting another view, which is that the confrontation clause doesn't apply when what you are opining about, when what someone is testifying about, is not something that is formally certified, but just sort of the result of the lab test's conclusions. That's a position that none of the other justices has adopted. So I would say that this remains, I think, a very unstable area of the law. The two fun points about this case, first of all, this is the first, Justice Breyer wrote another very interesting concurring opinion. This is the first opinion I know of the Supreme Court that has a flow chart. So, if you see this, and I don't know if you can see that, but it goes on for several pages, and it's very Breyer-esque, I must say. The second thing is, there's a very interesting footnote where Justice Alito made quite clear that the war is continuing over this one, as they say, they without arguing that the other decisions were wrong, they say, experience might yet show that the holdings in these cases should be reconsidered for the reasons, among others, expressed in the sense the decisions produced. So that's sort of Supreme Court talk for like no pasaran, right? We're not giving up on this. So that I would say we're going to see lots more cases in this area.
Thank you very much. Patty Millett, who's a partner at AP Young, a former assistant solicitor general who's argued 30-plus cases in the Supreme Court, has the even more daunting assignment of trying to discuss 3 different cases. No doubt some in summary form. The strip search case, stolen ballot, down in the SEC, TV indecency case.
I've got the alliteration docket. Strip search is stolen ballot and swear words. And so starting with the last first, the SEC versus Fox, this is round 2 in the Supreme Court, a challenge to their regulation of so-called indecent broadcasts on broadcast TV, the ones that are licensed by the FCC. And this is somewhat akin to Jones in the sense that we are seeing a clash between modern technology and the Constitution, and where are they headed with this. And by that I mean that when I was a child, TV had 3 channels, and you had to walk across the room to change those channels. And now there are 540,000 channels. And you press buttons, it's a completely different technology. And the issue is fine, but as to a very tiny subset of those channels of broadcast TV that gets licenses from the FCC. As to that teeny subset of channels, is the FCC's policy adopted in 2004, banning what's called cleaning expletives. And essentially, it is monitoring the speech, the thank you speeches of movie stars and rock stars when they get awards. And we need to protect the American children from hearing Bono or Nicole Richie. One might protect children from Nicole Richie for other reasons, but we protect them from their language. So it's long been a ban not only George Carlin's own dirty words on intentional prolonged streams of profanity. The question here is when you have a fleeting, indecent word or an additional challenge involving planned brief scenes of nudity and like TV Blue. This went off the air how many years ago? Right, but it's now in the Supreme Court whether you can have fleeting nudity on the TV. And it really comes down to a very interesting First Amendment question. And the Roberts Court thus far has been very pro-speech in its rulings. The outcomes have been very pro-speech. The opinions have been a bit more hesitant, and I think this term, both in this case and stolen valor, that I'll discuss in a minute, may see some drawing back and some hesitation and limitations on that. The decision, the SEC case, has not yet been decided. The oral argument suggested that there was much debate between whether there really was a value in having a few stations that parents could put their kids on and trust that they're not going to see Big Bird using nasty words, and as opposed to all of the other channels, and the computer game. The children can operate better than the parents as well. And so it really is a question of whether, I think no one can test that when I was growing up, the concern was the TV sort of invading the home, the captive audience, and exposing children to his words. And now people bring technology in, they bring massive amounts of information in, and the question is, given that so many swear words and so much nudity is coming into your home already, can the FCC sort of police this little island of expletive-free zone or a nudity-free zone? The fun part of the nudity ban was when counsel for the broadcasters pointed out that there were some nude statutes in the Supreme Court courtroom, and they said, well, really, we hadn't noticed. So the plain nudity thing is really a bit complicated. But I think there is some chance that we will see a narrower approach than many people had thought, I think, for this case. And that was when put on First Amendment challenge. So there may actually be some sort of compromise decision or I think it's likely to be a complicated decision. It was argued in January, so we've been wrestling with it for some time. Another complicating factor is Justice Sotomayor was recused, so it's an 8-justice court. Stolen valor was the other free speech case that we had. And this is apparently, I have realized, I think it's related to campaign finance, apparently it's very hard to get elected to the California Water Board. And so one of the things you need to get elected to the California Water Board apparently is a Congressional Medal of Honor. And so U.S. versus Alvarez involved Mr. Alvarez, while campaigning for the California Water Board, or a politician trying to get on the California Water Board, claimed that he had a Congressional Medal of Honor. Now, Mr. Alvarez has sort of an issue with claiming all kinds of things that turn out not to be true. And the issue in this case, again, Congress passed a statute criminalizing false claims that you've been awarded a military medal or on. So it's not just the wearing. There had been a long-standing ban on wearing medals that you didn't earn. But this now is simply the false, knowing, deliberate false claim that you wear. That you were awarded one of these medals. Can we criminalize that? Now, in the free speech arena, of course, a criminal ban on pure speech is the most extreme power the government can exercise. It's an extraordinary one. And the Supreme Court has already struck down, under the Roberts Court, has struck down such statutes in the past. But the difficulty here for the justices, they seem much, again, an oral argument, we don't have a decision yet. An oral argument was the end of February, so again, there seems to be some wrestling going on here. The debate was very much about whether this conferral of a military honor, a military medal, is a protected kind of speech, almost like a trademark. Don't think about the word Olympic. You can't go set up here. My children can't set up their Olympic lemonade stand, right? It's a trademark in the U.S. and you cannot. It's improper to use that word for your own benefit. The debate in oral argument here is very much about what kind of harm there is, what harm happens when people claim to have a medal. Does it diminish the value of people who really made these incredible sacrifices? Does it diminish the conferral of the statement that the U.S. government is making when it confers these things on individuals and the heroism that they demonstrated? Again, though, I think there are some backtones about technology, because we're now at a point when the ability to expose these people is greater than it has ever been before. And so there's some question, do we really need a crime for this? But I think, again, the justices were very, very conflicted. It could end up being very narrow in the sense that Mr. Alvarez's attorney conceded that there would be no chill from this ban, no chill of legitimate speech. And then the other thing, if you just want fun, read the oral argument transcript, because you can imagine for lies, you get everything from dating, extramarital affairs. We learn about Justice Sotomayor doesn't want guys that she's dating lying to her. So it's fun in that sense. And then let me quickly talk about the strip search case, which was argued for petitioners by our friend Tom Goldstein. And this is don't eat French fries on the metro lesson. Because if you can get arrested, the issue is if you get arrested for a minor offense, can you be not only arrested, taken to the police station, but can you be strip searched? And we get great details about the content of a strip search from the Supreme Court's opinion, in this case written by Justice Kennedy, a 5-4 decision. And the question is, can you do this? Or does the Fourth Amendment require some particularized showing of a risk of harm that you're trying to smuggle something in before we're going to strip search people who've committed just minor offenses? Poor Mr. Florence had been arrested on, the computer records showed that he had an outstanding warrant. It turns out he did not. The warrant had been cleared years before. Oops. But they managed to actually strip search him a couple times at different facilities while they held him for a week before they figured out the mistake. And the Supreme Court held, again, 5-4, that the strip search, at least when people are going into the general population, is reasonable. That there's no categorical bar to doing it because the police officers need to be able to ensure that people that are going into the general population are not bringing in weapons and all these other things that apparently people hide in amazing places on their bodies. And I'm sure with great comfort to Mr. Florence, they assured him that he should feel happy because to be strip searched, because that means everyone else is getting strip searched too. And if you're going to be in the general population, even if you're not smuggling something in, you want to make sure Bubba didn't bring anything into your jail cell with you. What is interesting about the case is you have concurrences from the Chief Justice who says that, look, while we're saying this here, there may be limitations in some cases, and his line was, we need not embarrass the future with our holding, which sounds to me kind of like, okay, we're here this time, but we're reserving the right in a different situation if someone's not going to the general population to not have such a rule.
Thanks so much. Roger, you're a professor at GW, one of the nation's leading experts on criminal law. Can you talk for us about the remaining criminal law cases after the strip search case, the Laffer and Fry plea agreement case, Dorsey, the crack sentencing case, and the upcoming juvenile life without parole?
Absolutely. Thanks, Tom, and thanks to ACS for having me, and all of you for being here. And although this term likely will be remembered for the healthcare decision, there were many significant criminal law cases. We've heard about a few of them already, Williams and Jones and Florence, Maples will likely be discussed today as well. And that's just a small sample of the important, interesting criminal law cases we had this term. And so until the healthcare decision comes down, I'm going to continue to claim that this is the criminal justice term until that decision comes down. That said, 2 of the 3 sets of cases I've been asked to discuss have yet to be decided. Jackson versus Hobbs and Miller versus Alabama deal with the issue of whether it comports with the 8th Amendment's cruel and unusual punishments clause to impose life without parole on a juvenile offender convicted of murder. Now, you'll remember several years ago in Roper v. Simmons, the court held that the imposition of the death penalty on juvenile offenders was unconstitutional, and a couple of years ago in Graham versus Florida followed up with the holding that the imposition of life without parole on a juvenile offender for a non-homicide offense was unconstitutional. So it's expected that the court will resolve the remaining question of whether life without parole can be imposed on a juvenile for a homicide or murder offense. There's been intense speculation as to what the court might do with regard to this, whether there might be a flat ban for all juveniles or whether there might be age-specific gradations, 12 years old, 13, 14. while leaving the older juveniles eligible for life without parole. So there's intense speculation about that, and we anticipate that those decisions soon. Another set of yet to be decided criminal cases are Dorsey versus the United States and Hill versus the United States, which deal with retroactivity issues related to the Fair Sentencing Act, which is the bipartisan legislation that President Obama signed, which reduces the crack powder sentencing disparity in ratio from 100 to 1 to 18 to 1. And although this legislation was seen as a tremendous drive forward for those interested in addressing issues of racial disparity in the criminal justice system, the administration initially opposed the retroactive application of the law to those who were convicted before the law became effective but were being sentenced after the law became effective. The administration has since changed its position, and the court is sorting out a circuit split over that question of whether that law will apply to all defendants sentenced after the law became effective. So again, that's another set of cases we expect in the last week of the term. So a case I am here, a set of cases I am here to discuss this afternoon that have been decided are Lafler versus Cooper and Fry. And those two cases really deal with the issue of the application of the Sixth Amendment's right to effective assistance of counsel to the plea bargaining context. And Lafler, the respondent, rejected a plea offer based on the incorrect legal advice of counsel, went to trial, was convicted at trial, and received a sentence that was much harsher than that contemplated by the government sentencing recommendation in the original plea agreement. And Fry, the respondent, never even got word of the plea offer that was extended by the government to his attorney. He did later plead guilty to a less favorable plea deal and was sentenced to a much greater term of incarceration than that to which he was exposed or would have been exposed under the original plea offer. And it's important for these cases to remember that the Sixth Amendment had already applied to the plea bargaining context. The court long ago applied the Strickland versus Washington standard to determining ineffective assistance of counsel claims in the plea bargaining context, and certainly very recently in Padilla versus Kentucky, the court reinforced that when it applied the Strickland standard to defense counsel's advice regarding the immigration consequences of a guilty plea and the resulting criminal conviction. But what makes Lafler and Fry significant is the fact that the court has now made clear that that Sixth Amendment right to effective assistance of counsel applies to the entire plea bargaining process, not just the guilty plea stage, but all throughout the plea negotiation and bargaining process. And so that Sixth Amendment protection applies to a plea offer that was rejected or that where the defendant didn't have the opportunity to accept it because of the ineffective assistance of counsel. And what the court said in these two decisions, it acknowledged that we don't live in a system of trials in the modern criminal justice system. The court said we live in a system of guilty pleas. Better than 9 out of 10 convictions come as a result of guilty pleas and not as a result of trials. And so that point, I think, is one that will have implications down the line. Now, there are a few questions that have been left open by these decisions. And the first is, what is ineffective assistance of counsel in the plea bargaining context? I mean, yes, Fry tells us that failure to communicate a plea offer to one's client would be deficient performance under the Strickland standard, and we can assume that inaccurate legal advice that would induce a defendant to accept or reject a favorable plea offer would also be deficient under Strickland. But the court acknowledged that plea bargaining and negotiation style will vary greatly from attorney to attorney. And how do lower courts determine whether a certain plea bargaining tactic is constitutionally incompetent as opposed to just being unorthodox? And so I think that's one of the questions lower courts are going to be grappling with. Another one relates to the prejudice determination. The court made clear that a defendant in this posture has to show by a reasonable probability that he or she would have accepted the rejected plea offer had it not been for the ineffective assistance of counsel. But not just that. That defendant also has to show that the government would not have withdrawn or rescinded that plea offer if it had the discretion to do so before the entry of the guilty plea, and that the court would not have rejected that plea agreement if the court had the discretion to do so before the entry of the guilty plea. So there are a lot of ifs there in those statements, a lot of speculation. It will be interesting to see how defendants make that showing on the ground. And also with regard to the remedy, the court acknowledged that there are a number of potential appropriate outcomes as a result of a showing of ineffective assistance to counsel in this context, including the lower court exercising the discretion not to provide any remedy at all. Justice Scalia argued in dissent that is somewhat odd, a somewhat odd position in response to the violation of a constitutional right. So it'll be interesting to see how that is fleshed out as well. But for me, what makes these decisions significant, and I've said it, is that the court has acknowledged the real world of criminal justice, where plea bargains are driving the system. And that acknowledgement, while it's refreshing in its own right, to see the court looking at what happens in the trenches, I think is more important for the implications it may have for the court's jurisprudence down the line, including whether to apply Brady to the guilty plea context, now that we've recognized the ubiquity of plea bargaining in our system. So I put Lafleur and Fluoride within that trend of the court taking over the modern realities of criminal justice, along with Padilla and Plata from recent terms, and I think we'll be more to come.
Thanks very much. Let's turn to the race and voting-related cases of the term, and I'm hoping to have an exchange between Tom Sines, who's the President and General Counsel of MALDEF, and Paul Clement, who argued all the cases we're discussing, about the Texas redistricting case and SB 1070, the Arizona case. So could we start with Texas redistricting?
Sure, happy to, Tom. Thanks for having me. The Texas redistricting case, I'll try to explain very quickly, but it's a complicated case because it involves a couple of different courts. Because what happened is you had the census, you had the Republicans who now had a clear majority in the Texas legislatures trying to do the redistricting. They did the redistricting through the legislative process. There wasn't a deadlock because the Republicans controlled both houses and the governor's house. So they got it through. Then Texas is a covered jurisdiction, so the plans that they got through the legislature have to get pre-cleared. Texas, in this instance, did something that's different from what a lot of states who are covered jurisdictions have done in comparable circumstances, which rather than go through administrative pre-clearance at DOJ, they went the alternative that the statute gives them of going into the DDC and trying to get judicial pre-clearance. That process takes a while, and that creates the dynamic that leads to the case that goes to the Supreme Court, because the DDC is taking its time dealing with the pre-clearance issue, and there are these elections coming up. And so there's something of a dilemma there, because there's an argument, of course, you can't use the non-pre-cleared maps because they're not pre-cleared, but you can't just default and use the old maps because everybody pretty much concedes that because of population growth, the old maps are, violate one person, one vote. And of course, the problem is perhaps most acute when it comes to the congressional election, because Texas has 4 new seats. So you can't just go back to seats that draw up, 4 districts less than you need. So you have to do something. And so there's a suit that's brought not in the DDC, but in southern Texas, where in that suit you basically have an effort to get the courts to draw some maps. And so the question that really gets the court's attention is whether or not in drawing those judicial districts you start with the non-pre-cleared plan, or whether in fact you start with the pre-cleared plan even though the pre-clearance process is still going on in DDC. So as I said, somewhat complicated. The three-judge court divides over this issue, with the majority saying that you basically treat the unpre-cleared plan as if it didn't exist, and the judiciary has to come up with something more or less on its own. Judge Smith dissents and says that essentially you should start with the pre-cleared plan, though he also says this is a big mess. We have conflicting advice from the Supreme Court, so almost a plea for the Supreme Court to take up the case, which they in fact do.
He said start with the pre-cleared plan or the unpre-cleared plan?
I'm sorry, I may have misspoken. Judge Smith says you should start with the unpre-cleared plan. So this issue goes to the Supreme Court. Perhaps the most amazing thing about this case is how quickly and how unanimously the court decides the case. Excuse me. The court, in something like less than 20 days from argument to decision, says that in fact the court should have started with the not yet pre-cleared plan in drawing these districts. Sort of recognizes that the pre-clearance process is important, but nonetheless, since the not as yet pre-cleared plan still reflects the latest judgment of the elected branches, it's still important to take that into account as at least a starting point for drawing the maps. And as I say, this decision is produced in less than 20 days. It is essentially unanimous. Justice Thomas writes a concurrence on his own. It's a remarkable piece of product by one of the newest justices on the court, Justice Curiam, which is to say it's a pure Curiam opinion, not written by any one justice. And in some senses, whatever you else want to say about this particular resolution, I think this decision and the way it was produced is a rather remarkable accomplishment for the Chief Justice, because as this case was being briefed, as the case was being argued, it did not appear foreordained to be a unanimous decision. And there was a real possibility for the court to divide over this case. There was a real possibility for it to be kind of a dramatic spectacle where the court was taking a lot of time deciding this case, and meanwhile the clock for getting elections to actually take place in Texas was ticking and ticking. And the court, and one has to assume this is largely due to the leadership of the Chief Justice, managed to avoid that, managed to get a decision that everybody could join that was done in remarkably short order. And on remand, the court essentially adopted a map that everybody could live with, so there was no subsequent appeal to the Supreme Court. So in that sense, whatever you think about the pros and cons of the decision, I do think it's quite a remarkable achievement for the Chief Justice.
Let me say it's rare, unfortunately rare, that the justices think of themselves as producing a collective result rather than each justice having his or her own opinion and summing them up to see what the outcome is. That is, not perhaps everybody, perhaps not anybody agreed with the resolution of the case, but you would think a court would more often submerge their individual legal views into the notion of what's a collective result.
Tom, can you both give your sense of Texas redistricting, but also then introduce the SB 1070 case for us?
Sure, Tom, but with an eye to avoiding stolen valor, I have to give a couple of disclaimers, which is, number one, I don't currently teach at any law school. And number two, I've never argued before the Supreme Court. Indeed, we generally try to avoid having our cases go to this Supreme Court. Cert petitions and all the rest of it. And indeed, with respect to the Texas redistricting case, the case in San Antonio before that three-judge court was in part about Section 2 claims by the Latino community represented by Maldiv and my colleague Nina Perales. And when the Supreme Court took this case, we were very concerned. Again, with that knee-jerk reaction, not wanting something to go before the court, and concern, particularly in this day and age, about what they might do, what they might say about Section 5 and potentially even Section 2 claims in Texas. But of course, in hindsight, the per curiam decision is eminently reasonable. It is one that makes sense. Basically, the court acknowledged that you start with the representation of the legislative intent in the unpre-cleared map. And then you are allowed, as the court setting up a map for at least the impending election in light of non-apportionment, you then look at the Section 2 claims and basically apply a preliminary injunction standard of likelihood of success. And you look at the Section 5 objections and you apply a reasonable probability standard. Is it reasonably probable that preclearance will be denied with respect to certain elements of the map that were alleged to be retrogressive in effect or in intent? And indeed, as Paul mentioned, when it went back to the court after the Supreme Court decided, it went back to the three-judge court in San Antonio, they adopted a map that in some respects is actually better for the Latino community and its claims and interests than the map that the three-judge court had adopted that went to the Supreme Court. Of course, you can understand, I think we should all understand why the three judges in San Antonio believed that what they were doing was appropriate. First of all, it happens in Texas, and Texas has a terrible history of redistricting, and they treated this like a more or less pure malapportionment, which actually happened 10 years before, 2001, when Texas couldn't adopt certain maps, and therefore there was a three-judge panel that had to, on a clean slate with new congressional districts involved, had to, on a clean slate, draw a map. Of course, that led to a new legislature in 2003, decided to redistrict again. Eventually that went to the Supreme Court, and Texas had to be told that it needed to create more Latino congressional seats than it intended to. A similar set of issues, of course, going on this year, where 4 congressional seats were gained by Texas as a result of 2/3 of the growth of Texas was from Latino communities growth. So our Section 2 claims basically were around getting additional congressional districts to recognize how much the growth of the Latino community had contributed to the gain in congressional representation. But again, the three-judge court had that history in Texas. 10 years earlier, another three-judge panel had to write a plan on a clean slate because no map had even been adopted. And second, there were indications already from the district court in Washington, D.C. that had the pre-clearance action before it. Those judges had already indicated that they had some concerns about whether the map that had been adopted could be or would be pre-cleared. So I think you have to give a little bit of sympathy to the judges in Texas as they went about doing what they did. But again, in hindsight, what the Supreme Court decided in its procuring decision seems quite reasonable and resulted in a map that was certainly better for the Latino community and acceptable to all the parties. Tom, you asked about the Arizona case. Of course, not yet decided. It was argued some 2 months ago. As you all know, SB 1070 was enacted in the spring of 2010. It was a tremendous change in how states had been addressing issues of concern around undocumented immigration. It does have some predecessors, perhaps Proposition 187 in California from 1994, the closest and clearest predecessor. That action, of course, never made it to the U.S. Supreme Court. So Arizona's adoption of SB 1070 and the immediately ensuing legal claims against it, initially filed by civil rights organizations, of which MALDEF is one, and subsequently filed by the United States government against the state of Arizona. Of course, when the federal government files their case, they're the big dog. They got the ruling preliminary injunction motion in their case, even though I just have to say as an aside, our preliminary injunction motion was already pending even before the United States case was filed. But again, big dog prevailed, and that's where the preliminary injunction was issued against 4 significant sections of SB 1070, and that is the action, the decision that went first to the Ninth Circuit and is now pending before the Supreme Court. Of course, as you also know, in 2011, 5 additional states followed suit and adopted immigration regulatory schemes that are in many ways like Arizona's, in some ways different. And those 5 other states, Alabama, South Carolina, Utah, Indiana, and Georgia, of course, also have legal claims pending against them and have had injunctions issued against many of the provisions involved in those particular regulatory schemes as well. The 4 provisions before the Supreme Court, 2 of them relate to law enforcement authority. One is the section that received the most media attention. It's often been called the show me your papers provision. It is a provision that would mandate that Arizona law enforcement in any lawful stop, detention, or arrest determine whether there is a reasonable suspicion that the person they have stopped, detained, or arrested is undocumented, and take steps beyond that to verify the person's immigration status. And coupled with other provisions in the total scheme of SB 1070, could ultimately have led to someone being taken into state custody, arrested, and even prosecuted. The other provision that deals with law enforcement authority would permit law enforcement officers, not mandate, but permit them to arrest without warrant someone who they believe has committed an act that renders them deportable or removable from the United States. There are two other provisions that work in tandem, I believe, with those two provisions. In some cases, could lead to what I described as an actual arrest after state by someone whose only wrongdoing is that they are undocumented. Those two provisions, there is one that basically creates a new state crime in Arizona for being undocumented, and that's what could have led the reasonable suspicion, inquiry, determination to an arrest for violation of that new state law. And the other creates a state crime in Arizona for seeking or accepting work if you are not authorized to work, another provision that's targeted at the undocumented community. So those are the four provisions. I think that based on the oral argument, it's unclear, of course, as it always is, where the court will end up, though it does appear that they will end up with possibly differing decisions, conclusions about those different provisions. I think what's interesting about SB 1070 is that the Supreme Court took the case up as early as it did. It is on a preliminary injunction. As I said, there are 5 other states facing cases against them in other circuits. In those cases are winding their way up through the process as well. And at least I would expect the Supreme Court to wait a little bit, there being no particular urgency, trust me, even from the perspective of the proponents of 1070, I don't think there's any real urgency about wanting to actually enforce this law. So I think it is interesting that they took it up as early as they did. And the other thing is that this really is the first occasion for the Supreme Court to determine the issues of supremacy and preemption with respect to law enforcement powers under a modern immigration regulatory scheme at the federal level. There are old cases dealing with law enforcement authority at the state level, but really there before the United States government itself had as well developed, as complicated and variegated a scheme of enforcement with respect to immigration acts as we have today. There are immigration preemption supremacy cases in the interim, but they have not dealt with, a major one being Picanis versus Vika, they've not dealt with law enforcement authority or mandates as are involved in SB 1070.
Sure, and just a couple quick thoughts. Just one last thought on the Texas case. And I think Tom's comments really sort of capture, I think, something that's an important takeaway from the decision, which is it really does, I think, draw a big distinction between those situations where the legislature deadlocks and there just is no plan whatsoever, and so the judiciary has to draw up a map in those circumstances, however reluctantly, because there's just no alternative. And I think the court draws a pretty clear distinction between that and situations where, okay, the legislature has enacted a plan. The problem is it hasn't been pre-cleared. But in that situation, I think the court maybe reflected an understanding that the judicial role here is sufficiently dicey that you don't sort of look, any guidance askance. And so if you have a product of the legislative branch, even if it hasn't been pre-cleared, you still look at that as part of the process. And so I think kind of in thinking about the cases that are out there in the area, it's probably worth sort of drawing a distinction between those cases that arose in the deadlock situation and those cases that arise in the non-deadlock situation. On SB 1070, not too much to add to a very good summary of the issues that are at stake. Obviously, we don't have the opinion. I do think it's worth maybe putting a spotlight, though, on sort of the interesting position that the United States government, the big dog, finds themselves in these cases. Because, Tom's more of an expert on this than I am, but I understand that some of the other litigation that's been brought, there are also constitutional challenges, equal protection challenges, and the like. And of course, the federal government, which, however this case is decided, is going to be a principal enforcer of the immigration laws, would probably have some difficulty accepting the idea that there are robust equal protection limits on their enforcement authority. So in a sense, it's natural that the federal government comes in and doesn't make those arguments, but focuses on the preemption arguments. And if you really look, and indeed I believe the Chief Justice made it very clear at the beginning of the argument, this case before the Supreme Court this term is about the preemption issues and is not about the constitutional issues. But then that does create, and I'm not in any way suggesting how the court will decide this case, but it does create a bit of a difficult situation for the federal government because, so in any preemption case, you look at the text of the legislation that was passed, and many of the provisions that are at least arguably relevant in this case were a product of a 1996 effort to revise the immigration laws that was done by a Republican Congress. And so it's maybe not shocking that there are not provisions in there that obviously preempt something like SB 1070, and there are actually some provisions that seem like they were directed at actually overcoming state laws that were actually kind of the opposite of SB 1070. So anytime you make a preemption argument, I think just the takeaway is there's a reason you can understand why the government's emphasizing preemption rather than the Constitution. But any time that you make a preemption argument, you are stuck with the statute that you're arguing does the preempting. And it'll be interesting to see how the court sorts through the issues as a result of that.
Thank you. So we are 2/3 of the way through our time. We haven't done healthcare. So, healthcare. Will you set the table?
Yeah, I'll set the table. Actually, I'll give you the hors d'oeuvre and the dessert, but not the main course. How about that? So I know a lot of you have followed the healthcare cases very closely, so it doesn't need that much introduction. I do want to say, I want to first mention just briefly the Medicaid, the challenge of the Medicaid expansion, because I think in terms of the progressive policy objective of making healthcare both universally accessible and affordable to all Americans, the expansion of Medicare deserves as much, is equally as important, if not more important, as the mandate that we will discuss. And is subject to a separate constitutional challenge on the ground that essentially the federal government's expansion of Medicaid to cover essentially everybody who is at or below 135% of the poverty line. A huge change of eligibility from what it had been, where it was really kind of bits and pieces. People who were, poor and sick, or old and sick, or pregnant women, or children. Now it's really is across the board comprehensive coverage of lower income Americans. Medicaid is a federal state cooperative program. The states do not have to enter into Medicaid. Once they do, the federal government gives them a lot of money, but the deal is you get our money, but you have to abide by all of our rules. And theoretically, if you don't abide by at least any of our rules, we can take all the money back. So it's kind of an offer you can't refuse, is the state's argument. Basically, and the states would say, look, as a matter of, reality, we have to render this deal. This is no choice. This is, we are being coerced. And the Supreme Court has said on occasion that, there is a limit past which the federal government inviting the states to participate in the funding program is really an invitation you can't refuse. And the states have argued in this case that, look, if that argument has any meaning whatsoever, it's got to be this case, because the consequences of not accepting all of the conditions that the federal government has put on Medicaid, including that we cover everybody at or below 135% of the poverty line, the consequences of not going along with it are so colossal, potentially losing all Medicaid funding, that essentially we're being forced into doing this. So that's in very brief the Medicaid cases. The other issue we'll be discussing, of course, is the mandate or the minimum coverage requirement. As most people know, the mandate works closely in relationship with two other provisions that are sometimes referred to as the guaranteed coverage and the community rating provision. Essentially, the idea is insurers are no longer allowed to either refuse coverage to or discriminate in pricing against people by virtue of they or their family's pre-existing medical condition, but to deal with kind of the adverse selection problems and to deal with moral hazard. Essentially, the kind of other piece of that is everybody has to buy into the health insurance system. So, this essentially guarantees a flow of customers to the insurance coverage because of the way insurance works, which is essentially spreading costs across the entire pool of people being insured. That makes makes the guaranteed coverage provisions and the non-discrimination provisions affordable. It makes them work, because otherwise they would be so colossal. They would make the cost of insurance colossally expensive. So folks will discuss that. The two issues framing that are, first, does the court even have jurisdiction to consider these cases? There is a statute that has been around for 150 years, the Anti-Injunction Act, which deprives the federal courts of the authority to hear challenges to taxes in a pre-enforcement setting. The argument has been made that that these are taxes, because if you don't buy the health insurance coverage, you then pay a tax. You then are required to pay a tax penalty, subject to various exceptions. So it has been argued that basically this should all wait until the tax penalty actually goes into effect, and then you can challenge that. This is all too early. So that's the kind of the hors d'oeuvre that the court had to go through before it got to the mandate. Then there was the dessert, which is, well, suppose we agree with you that the mandate is unconstitutional. What happens to the rest of the 2,400-page law? That is involves the doctrine of severability, which the question is, when the Supreme Court strikes down one part of a law, does any other part of the law, which would not necessarily be unconstitutional, does any other part of the law have to go with it? How much of it goes with it? Does the whole law have to go with it? I think it's fair to say that Supreme Court decisions on that issue are very difficult to reconcile, and the oral argument really showed, I think, the court struggling with trying to arrive at a workable formulation about how to deal with that. The government, I think, I won't get too far into this, but on both of the issues that I just discussed, the government has really kind of changed its position over time as it thought about it, as it thought about the issues and the implications of it. The government was in the position in the Supreme Court of saying, go ahead and rule on the mandate issue. The Tax Injunction Act doesn't apply. And on severability, the government said, well, you shouldn't reach any of the issues, but if you reach any of the issues, you should strike down some of the rest of the law, but not all of it, which is a little bit difficult to follow, I know. The experts will now turn to the constitutionality of the mandate.
Paul, you're responsible for this menu?
Well, no, the court's responsible for the menu, which I think it's worth just pausing for a second, because Paul's done a great job of laying this out, and it really is pretty remarkable. And we did not go to the Supreme Court. I mean, obviously, the government filed a cert petition when it came to the mandate, because the states and the NFIB prevailed in the 11th Circuit on that issue. And then we raised the Medicaid issue in our own cert petition. But none of the parties went to the Supreme Court and said, what we'd like is 3 days of argument. And we'd like it divided among 4 issues, so that there'll be a full 90 minutes, for example, on severability that will include discussion by justices who think the whole thing's constitutional. I mean, it really was a remarkable way for the court to structure the argument. And one of the reasons why neither we nor the government asked for this is, I think we would have thought we would be making laughing stocks for ourselves to ask the court to have 3 full days of argument on a single case. I was in the SG's office back at the time that the McConnell case was argued, which is kind of comparable in its size and scope. And remember having extended discussions about what's the most we could possibly ask the Supreme Court to have argument in this case. And the number we came up with was 4 hours. So in this context, the court, really acting on its own, gave the sides 5.5 hours, and then ultimately 6. And then the severability argument even trickled over into bonus time. So by the time it was all said and done, you had over 6 hours of argument over 3 days, all divided up in this way that was quite extraordinary. And just the last thing I'll say before letting other people jump in about other aspects of this issue is, it did create a very different dynamic, because when we argued the case in the 11th Circuit, I thought one of the best signs for the states in the 11th Circuit argument was that there were so many questions from the judges about severability. Because you don't ask about severability if you think the whole thing's constitutional. And in the Supreme Court, obviously people have fly-spec the transcripts of these arguments back and forth, but the way that it was structured, doesn't allow you to draw conclusions the way that you might have been able to draw some conclusions if it had been sort of a 4-hour free-for-all. I mean, I can't quite imagine what that would look like. But it is, the structuring of this and the fact that we didn't ask for it and the court gave it to us is something that is really pretty extraordinary. I don't know if we'll ever see anything like it again. Walter?
I think what's most interesting about the case is the conflation of two different issues that seem to be confused in the minds of the justices. One is the issue that is acted before the court, which is whether this is within the subject matter scope of being a regulation of commerce among the states. That's a question that a lot of people thought was a very easy question. Orrin Kerr, who clerked for Justice Kennedy, a relatively moderate conservative, said there's a 1% chance that the court would strike this down, and that's because even if it is a requirement that people purchase insurance, and even if the same thing would apply to a requirement that you purchase other products, that's still, if you're purchasing those products as part of interstate commerce, that's still a regulation of commerce among the states. You can raise a lot of parade of horribles. Just as you can say that when it's a regulation of commerce to have a $5,000 minimum wage in interstate commerce, it would equally be a regulation of commerce to have a $5,000 hour minimum wage, even if other issues could be brought. What drove the attack, however, was an issue not brought, and very wisely, I think, by Paul Clement, not brought to the court, of whether it violates the sort of substantive due process liberty to force someone into a transaction, whether this particular way of regulating interstate commerce raises these issues of individual autonomy. And but what was struck that was not brought to the court. I think that argument, if it was brought, is one that should not prevail because the only penalty maxes out at a 2.5% increase on your federal income tax, so that you could, the government says you're free to choose not to engage in a transaction with another private party and just pay the penalty. And since it's 2.5% and Social Security tax is 7.5%, what's the big deal? But what was striking to me when I reread the transcript is that almost overwhelmingly the critical questions asked of the government were questions that sounded in substantive due process. Isn't this extraordinary requirement? So Justice Kennedy said, doesn't this fundamentally transform the relationship of citizen to government? It has nothing to do with whether it's within the subject matter of commerce, I think. And that while there is a liberty-protecting aspect to limiting the federal government to staying within the scope of commerce, that's not what they're asking about. They were asking about the sort of individual autonomy question, which I think is easily answered by the modest nature of the penalty. Or they were asking about whether it's redistributed. Justice Alito's questions were about redistribution, to which the Solicitor General replied, we resolved, that's 1905, we resolved the question of whether it's legitimate for Congress as a constitutional matter to engage in redistribution. So I think those are that confusion and conflation of what should be a simple question like who's buried in grants too. Is this regulation of interstate transactions and insurance a regulation of interstate commerce has been conflated with another issue not raised. I'm wondering whether the court might possibly do something undramatic. And that would possibly be to really focus on the fact that the government says that you're complying with the law if you pay the penalty. You're in compliance. And to say that it would be unconstitutional to require people, to actually force people, to mandate people to engage in a transaction like this, so that it can't constitutionally be applied to anyone, except taxpayers can be required to pay this penalty if they don't have it. That the penalty is okay, but the, quote, mandate isn't, which would make no change in the operational law at all, but preserve this idea that you can't be forced into a transaction with a private party. At least Congress can't do that.
Just by way of disclosure, I filed an amicus brief. There are about as many amicus briefs as there are channels on your television. In this case, but I did it for the health insurance industry. It was only on the severability question. They didn't take a position on minimum coverage, but I'm not speaking as a representative of them. I'm speaking in my personal capacity. And I don't know about the rest of you, but sitting here listening to this entire buffet of issues in the Supreme Court reminded me of what a friend of mine said last fall. And he said, we need to take everything that's before the Supreme Court this term group it together and label it in re what kind of country we want to live in. And I think at some level, the Supreme Court has hit this point, and there's more coming next term, where so many of the debates everyone is having outside courtrooms have parallels now in the court itself. But as Walter suggested, and as Paul explained with respect to the Arizona case, the cases come to the court in a different format and raising different questions, and I think a lot of the public debate that's going on. With immigration, a lot of the public debate is about the racial profiling consequences of this, but it's preemption in the Supreme Court. For a lot of people, their understanding of minimum coverage or mandate is precisely a liberty objection, and they would be equally appalled. And in fact, I think someone interviewed Ms. Brown, who's one of the main plaintiffs. Wall Street Journal, I think, was down and interviewed her, and she would be just as appalled to have her state mandate that she buy insurance. Now, I disagree a little bit with Walter because I believe, and I think Justice Kennedy believes, that what I sort of call the horizontal separation of powers between federal and state government, and Justice Kennedy and the collection on the Supreme Court have understood that as not just regulating one government versus another, but that regulation is itself designed to promote individual liberty to some extent. And so you're getting the liberty argument through a very different prism than I think most people have the debate on. The other thing that I thought was very, very interesting was this, and nobody else does, but the severability argument. I won't talk about any Injunction Act, which I also thought was interesting. But the severability argument really showed how muddled the severability law is in this area. And you saw, I think, some interesting questioning from the justices about what really is the role of a court in a situation like this. Traditionally, with severability, the court is very, very narrow and careful and surgical. Okay, we found this thing unconstitutional, let's pluck it out and leave everything else that's been enacted by the duly elected representatives in 2 houses and signed by a president untouched. But you had concerns, I think, from a number of the justices here that this case doesn't fit that model or may not fit that model because if you pluck this out and leave the rest there, if you take away minimum coverage, you don't have to buy insurance. And you can get it anytime you want in any condition you're in. The guaranteed issuance insurance and the ban on pre-existing conditions and health-related pricing. Who's going to buy insurance? And so there was a real risk. Is the judicial restraint to go narrow, or do we then create a Frankenstein of a statute that functions in a way that Congress would never have wanted and actually is a completely different animal? And so I think they really are wrestling with sort of fundamental concepts on severability in a way they haven't before.
Let's turn, in the time that we have left, which is about 10 minutes before we want to be certainly getting questions from the audience, to next term. So, Walter, very briefly, can you tell us about the gay rights cases that could be coming?
2 cases are coming towards the Supreme Court. They should be arriving at about the same time. One is the decision from the Ninth Circuit, which held that the California referendum Proposition 8, which restored opposite-sex only marriage as the law of California, the Ninth Circuit held that that was unconstitutional because it took away a right that had already been created, and also because since the state had already extended benefits to same-sex partners, it only took away the designation marriage, which made it less rational for the state to do that. The other case that's coming to the Supreme Court is the Defense of Marriage Act. The Gill case was decided by the First Circuit, and Section 3 of the Defense of Marriage Act changes what had been for 200 years the practice of the national government of not having a national rule about what constitutes a marriage or a spouse. For 200 years, there are hundreds of federal statutes that use the term spouse or marriage. And for 200 years, whether you qualified for that designation simply depended on whether the law of your state recognized your relationship as a marriage. DOMA says for the first time, fearing that some states will allow same-sex couples to be married, DOMA provides that marriage or a spouse can only be a person of the opposite sex for any federal law purposes. It was done without hearings. It's an astoundingly sweeping law. And the import of DOMA is hard to overestimate, because it really means that there is nowhere in this country where gay couples are really married. You're not really married in New York. You're not really married in Ireland, because when you die, the federal law, estate and gift tax, does not treat you as if you've been married, even though New York says that you are. Your estate does not pass to your spouse without tax incidence, the way it does for everybody else. The person you marry in New York is not a person that's entitled to Social Security benefits of a surviving spouse. And the list goes on to hundreds of items. So in spite of what those states can do, DOMA is overriding. That's why the DOMA case is a very powerful case to go to the Supreme Court, because states' rights and gay rights are on the same side, which means that I think people are anticipating this is a particularly appealing challenge to restrictions on gay marriage to be brought before Justice Kennedy. And indeed, the First Circuit, which was bound by circuit precedent to say we can't have heightened scrutiny, we can't require a compelling interest, whatever, nonetheless said that you need closer than usual review of the asserted, it's a great phrase, Judge Modine's masterful phrase, of the asserted federal interest behind DOMA, because in areas where state regulation is traditionally governed, the court may require the federal government's interest to be shown with special clarity. And here, the federal government is overriding what had been a traditional state function, where the federal government has never had a role in regulating domestic relationships, and therefore the federal interest is diminished. Let me just say that what poses these cases is really interesting dilemma. If the strongest argument for attacking DOMA is to say that the fact that the federal government is intruding into an area that has traditionally been left to the states counts strongly against it. But that is in tension with the argument that you might make that there's a federal constitutional right to nationalizing same-sex marriage. The tension may be more apparent than real, in the sense that the diminished federal interest does not mean that you don't judge the state law just as you would if there'd never been a DOMA. But there is some tension, and the president's statement very much says that this is saying that he supports the attack on DOMA, very much says this is an area to be left to the states. So that is in tension with the attack. Finally, I think the California case has some problems. I don't think the California case will lead the court to consider whether there's a equal protection of due process right to gay marriage. The state didn't appeal. The referendum supporters appealed. Judge Reinhart's opinion says that the fact that a referendum took away a right that previously existed briefly in California is what counts against it. That's a very narrow claim, one that doesn't apply to other states in the Ninth Circuit, one that may not be, as I think, as persuasive as the other grounds, and one I'm not certain there's anybody that has standing to present to the Supreme Court. So it's possible the main action will be DOMA, and that it will only be limited to the question of setting aside DOMA's override of those states which have chosen to recognize same-sex marriage.
Paul, although I didn't ask you in advance to do it, could you just is there anything you wanted to add with respect to DOMA? You've been hired to defend the constitutionality of the statute.
Yeah, no, I mean, the only thing I would add is, one of the points that Walter made is an interesting one, which is, as Gil comes to the Supreme Court, presumably the focus is going to be on the equal protection argument. But there is, the challengers to the law there have also raised the 10th Amendment argument, and really squarely presenting the federalism issue. And that's an issue on which, at least in the lower courts, the Justice Department has continued to defend the statute against the 10th Amendment issue. So that's one that will be interesting as the case moves to the Supreme Court to see whether the 10th Amendment issue remains part of the case. I mean, presumably it would, because it would be an alternative ground. So even if it's not in the petition, it would be an alternative ground. And it'd be interesting to see how the Justice Department deals with the 10th Amendment challenge in the context going forward. So it'll be something kind of interesting to watch.
Paul, campaign finance?
Sure. This will be brief. You all may have heard of the Citizens United case, in which the Supreme Court held invalid the federal law that prohibits corporations from engaging in independent expenditures with respect to elections. So, not touching the ban on corporations contributing to campaigns, but corporations engaging in supposedly independent expenditures. I'll leave you to judge whether these expenditures are really independent, but that's on the assumption that it is. And the court's reasoning was that there was no record that had demonstrated that corporations like anybody else engaging in independent expenditures created the problem of either corruption or the appearance of corruption or improper favoritism. That the government would have a legitimate basis for reacting. So it didn't, it wouldn't matter that the corporation would engage in what can now be unlimited expenditures to support the election of a particular candidate, that because those expenditures were independent, there was sufficient separation so that we need not worry about either corruption or the appearance of corruption. Montana has in some ways a similar law. In some ways it's a little bit different because of the administrative burdens that it places on corporations is much less. A corporation, even under federal law, was always the case that a corporation could set up a segregated fund, not out of its general treasury, but people could voluntarily contribute it, which the corporate PAC could then use for campaign expenditures. That's true in Montana as well, although the fund is even less separate. It's really just kind of a separate bank account. But Montana has a similar law. It dates from the Progressive era, the same era, and it was a reaction to sort of massive corporate, essentially, where the Montana legislature was sort of bought and paid for by mining interests in the state. And it was a reaction to that, along with many other progressive era reforms, such as the referendum and the initiative and the nonpartisan judicial elections. That law was challenged on sort of similar basis to Citizens United. The Montana Supreme Court, I think most people would say in a surprising decision, upheld the law and said that unlike the federal law, there was a long history of corporate corruption of the electoral process in Montana, and that the Montana legislature was entitled to react to this historical showing, which was considerably different than the federal record that the Supreme Court had reviewed in Citizens United. I will leave it to you to judge whether the showing has been made that the corruption, that the record of corruption is from independent expenditures as opposed to just straight out corporate donations, which I think is going to be really important to the Supreme Court as to whether that record of independent expenditures being corrupting is made. Anyway, the plaintiffs who were seeking to invalidate the Montana law have petitioned the Supreme Court for review, saying, look, this is just, the Montana Supreme Court is just thumbing its nose at Citizens United. Please tell them that Montana is, part of the United States, and the Montana Supreme Court is actually a lower court to the United States Supreme Court. There are there's a lot of speculation about what the Supreme Court would do. Very unusually for a Supreme Court case, many amicus briefs have been filed for the respondent in this case, essentially telling the Supreme Court, look, please take this, even though we agree with the Montana Supreme Court, you might actually want to take this case and sort of give some thought to, to the continuing scope or vitality of Citizens United, and perhaps reconsider it. The Supreme Court actually had this case for its conference last week. It did not take any action on it on Monday, which suggests that the court is still thinking about what to do, and we will probably hear next Monday whether they will agree just to hear the case next year, or whether, as some have speculated, the court might just reverse the Montana Supreme Court 5-4 and say, reverse C Citizens United, or something else. I don't think most people expect the court to turn down the case completely, but this could be a big one for next year, or it could be just a kind of last shot at the end of this term.
Tom, Paul, let me come back to you, if I could, on two further race and voting related cases for next term. One granted and one of the body cases that's likely on its way. Fisher on affirmative action, Tom, and then Section 5 of the Voting Rights Act.
Well, the court has granted review of Fisher versus Texas, another case out of Texas, that revisits the issues of affirmative action that were addressed by the court 9 years ago in the University of Michigan cases. It's an interesting affirmative action, race-conscious affirmative action program at the University of Texas. It was layered onto a pre-existing race-neutral program, the Top 10% Plan, that basically granted admission to anyone in the top 10% of their high school, and relying on segregation, enduring segregation of Texas high schools, that led to significant amounts of diversity, and that accounts for over 4/5 of the admissions to the University of Texas. But after the University of Michigan decision, the University of Texas drafted onto that top 10% plan a program that is whole person consideration of those who are beyond those 4/5 that are admitted to the top 10%, and particularly with regard to certain programs where diversity was conceivably lacking. And among the considerations in evaluation of the whole person who is applying, they do consider race among other factors. Obviously, this is a matter of concern. This is a case in my mind when I said we try to avoid having cases that we're involved in go to the Supreme Court. A little bit of a surprise because Justice O'Connor, of course, no longer on the court, but in her decision in the University of Michigan cases indicated that she believed that what was being pronounced then should be the case for 25 years. It could end up being a decision that is only about the details of application of either the diversity basis for race-conscious affirmative action program, specifically what critical mass, the term that was used in the Michigan cases, means, or it could be about narrow tailoring, specifically whether this program is narrowly tailored enough in light of the diversity already achieved in the top 10% plan, or it could be a wholesale revisiting of the issues that we may have thought were settled for a quarter century in the University of Michigan.
And Section 5, there's no case that's currently on the court's docket that raises the question of the constitutionality of Section 5, but there are a lot of cases, I guess most prominently the Shelby County case and the D.C. Circuit, that have the potential for that issue to get before the Supreme Court. And obviously ever since the Namundo case, where the issue was teed up, and the court rather surprisingly came out with a nearly unanimous resolution, not resolving the question. I think this is something that watchers of the Supreme Court have recognized, that there's a real possibility that the constitutionality of Section 5 will get before the Supreme Court before too long. And so there will be multiple opportunities for that to get there next term. No guarantee that the court will take it, but I think it's their ability to not take it is in some ways affected by the fact that at least some of the issues in which the Constitution, cases where this constitutionality of Section 5 is raised, are cases that are appellate jurisdiction cases coming out of 3-judge district courts. And so a little bit, even if the court wanted to defer deciding this case for a couple of years, it may be harder to do so. You can always deny cert, but it's a little harder to not know probable jurisdiction when you have a case that's coming to you on the appellate docket. And then, this is not to suggest that it's obvious that the court wants to dump this question. One of the most, I think, interesting questions in the oral argument in the Texas redistricting case was from Justice Kennedy. And whereas most of the justices seem to, in the context of a Texas redistricting case with a very tight time deadline, I think most of the justices wanted to keep Section 5 in the backdrop. Justice Kennedy raised the question, and he echoed something that I think is lurking in some of his opinions, which is this idea that that Section 5 is in tension with Section 2 of the Voting Rights Act, and that I think maybe in his view, anyways, it's important for the court to actually take up the issue to figure out whether Section 5 and Section 2 can be reconciled, or whether they are in such substantial tension that maybe the court needs to really focus on the issue. So, without trying to say that absolutely the Section 5 issue will be up there next term, I think it's quite likely that it will get up there either next term or the following term, in part because the ability of the court to not take on the issue with so many cases raising the issue on the appellate docket, I think the court's going to really almost have to face it sooner rather than later.
Terrific, thank you. All right, let us take a few minutes to do questions, and I want to start with questions from the press. Please, I assume that we have, we've got microphones around, or maybe not. So, yeah, we'll be sure to repeat the question. So, yes, sir, if you'll identify and give your affiliation.
My name is Ibrahim.
Hold on just a second.
My name is Ibrahim Fukara from Al Jazeera Television. As you probably know, the Egyptians, as of today, are heading towards their own version of Gore versus Bush 2000.
We export such wonderful tools to market.
Both presidential candidates there are claiming victory in the presidential election. Now, 12 years on, do you think that the decision to go to the Supreme Court for a decision on that was the right choice, or do you think that both the step and the decision have done irreparable damage to the credibility of the electoral system in the United States? And if I may ask one more related question, the Supreme Constitutional Court in Egypt issued a ruling which nullified the Egyptian parliament. Is there anything resembling that in the history of the United States, and what mechanisms are there in place, if any, to make sure that the Supreme Court of the United States does not undermine in any way, in theory or in practice, the legitimacy of the Congress? Thank you.
That is a very powerful question about the relationship of judicial review to majoritarian government. They're obviously in tension. If you have a system of rights that ensure pluralism, that ensure the right of access to every element of your population, to higher education, to occupational freedom, you have a majority that votes that down, it creates the greatest tension. On Bush versus Gore, I thought at the time, and still think that under our Constitution and under the statute, it was a function of Congress when it came to counting the electoral votes to resolve any dispute over a state's award of an electoral vote, and thought that should not have gone to the Supreme Court, should have let Florida come to its final conclusion and let Congress resolve it. And that it has had such enormous ripple effects in our country to think that 5 out of 9 people resolved that election, that I think is striking. You know, you're facing the question we faced for 200 years. Is active judicial review a good thing in a democracy? And I think the answer is like what Joe Enlai said when asked whether the French Revolution was a success. He said it's too early to tell.
Paul,
I was going to say, I think that we are really in a period of remarkable transition about how progressives and conservatives, using those terms, however you want, think about judicial review. And, Bush versus Gore, Citizens United, and perhaps the healthcare cases, may really, it may lead to a complete rethinking about people's views about the role of the federal courts. For years it has been, one side was for what they call judicial restraint, and doctrines like standing and rightness and mootness were all parts of keeping the courts out of disputes. But today we have George Will saying, unleash the court, let's have some judicial activism. And yet we have Tom here saying we like to keep the courts out of our business as much as we can. So I think we are in a position of really remarkable transition in the way we're thinking about the Constitution, to the point where, Professor Tribe said, I can't even finish my treatise because nobody agrees anymore on what the rules are on constitutional law. So we are definitely, not at a stable point in the way that people think about these issues.
okay. In the back.
Ken Joseph with CQ Press. To what extent do any of you see the lineups among the 9 justices becoming, how can one say, more diverse than in the past few terms?
I'm not sure I understand. I'm not sure I appreciate the question. I mean, I think one of the things that is just a troublesome fact about the court is that for the first time we have an alignment in my lifetime of ideology and political party, or approach to law and political party. We had Republican people who had been active in the Republican Party, appointed by Republican justices who were on the more progressive side, Justice Stevens, Justice Souter. That's all changed now. We have 5 Republican appointees who tend to be conservative and 4 Democratic appointees who tend to be liberal, and the 5-4 breakdowns tend to go on that ground, which is really the first time that I know of in our history where we have that kind of 5-4 breakdown. So it's very, very troublesome in the sense that if you try to predict the outcome of the healthcare case, scholars will debate forever what the implications of Wickard against Filbert were, and how you relate the concurring opinions in Comstock. And the taxi driver will say, well, how many Republicans are on the court? And 5, and that's the answer. And the question is, if we have a series of cases that seem to reflect the fact that the taxi driver is right and the scholars are wrong, it'll be a troublesome fact about the world. I don't know what to do about that.
Yeah, I guess I would try to put a slightly more glass half full spin on that, which is to say, the premise of the question is that that the important decisions are all 5-4, and we know which 5 and which 4, or at least which 4 and which 4, and maybe which way we get to 5. And I think if you look a little closer, you see that it's actually a lot more complicated than that, and you do see. Probably the best illustration. I could talk about other cases this term that have been decided by unusual divisions, 6-3 with kind of people mixed up, or we can talk about the Williams case with and all of the very important Confrontation Clause cases that are constantly decided by a very unusual mix of justices, but tend to be decided 5-4. Or we could talk about one of if not the most important criminal law case of the last decade and a half, which is Apprendi, which revolutionized the way that criminal sentencing takes place in this country, and again was a 5-4 series of decisions, but not your typical 5-4. And then you can reflect on the fact, I think somewhat, it's happened before in previous terms, but I think this term is remarkable in a term that's rich with tremendously important and consequential cases. That that we haven't talked about a number of cases that last term would have merited a good 10 minutes of discussion, because we had very little else to discuss other than violent video games. But they didn't make the cut. And yet, in talking about some of the most consequential decisions, we've talked about a number of decisions that were 9-0. Hosanna Tabor, 9-0. We've talked about the Texas redistricting case, 9-0. We could have talked about Sackett against EPA, another 9-0 case. So there are, even in an era where some cases on some issues are going to be 5-4 and predictably 5-4, we also have a recognition and a reminder that on many very important, very consequential issues, Jones also 9-0 effectively that result. We do have a virtual unanimity of the justices. So in that sense, I think that I take Walter's point, but I do think it's worth reflecting on the fact that to the extent you're concerned about this, the glass is also half full.
I think one of the things that you may want to just look for going forward, this may even be more next term than this term, is distinguishing the breakdown of votes between constitutional questions they're deciding for the first time and ones they're revisiting. The thing we never got in law school is stare decisis. And how votes break down along that line. Stare decisis looked at the same way in the Montana case. Citizens United get the same stare decisis effect as Gratz and Gruner. I think one of the things that I've said a lot of people about Citizens United, besides the practicalities of it, was the stare decisis question. And these are the types of things that came up at everyone's confirmation hearings and what they mean by that. And so watching to see whether we see splits amongst what people call the 5 on application of stare decisis principles. We may even see some of this in cases still this term, finding narrow ways to go rather than broad ways, because that avoids having to overrule precedent or not. So I would look for how they line up on stare decisis questions going forward.
All right, let's do one final question and then let you all go. Over here, this side.
Hi. Gloria Brown Marshall with WBAI Radio in New York. There are those who believe the court is out of touch with the common regular person, and looking at the decisions, for example, Florence, which allows a person to be strip searched if placed in general population. The Estrue case that was recently decided, in which a woman who conceives a child through IVF, 18 months after her husband has died, is not allowed to collect survivor benefits for a child. It kind of ignores what's happening with the regular person in the world. And I was just wondering, what would you say to the regular person who's looking to this third branch of government to see them in their lives and not see it strictly as some legal detail?
I think that's an excellent question. In the context of criminal justice, certainly, as I mentioned, I think the trend that's starting to develop shows the justices beginning to roll up their sleeves and really take account of what's happening in the real world. A lot has been made of the fact that Justice Sotomayor and Justice Alito were prosecutors before taking the positions they have now. Justice Kennedy certainly has done a lot outside of his role as Supreme Court Justice to look at the issue of mass incarceration. Has been very active in that regard. So in the area of criminal justice, which affects the lives of most Americans in some way, shape, or form, I think you're starting to get the sense that the Supreme Court is beginning to engage with some of the broader issues impacting society. Now, certainly there are other areas, and you made reference to another case where we may not have that same sense. But certainly the area of criminal justice, there is a good deal of optimism that you're going to see more of that as we go forward.
Sorry. Certainly in the habeas corpus area, I see them going further and further into this just complete procedural unreality of what it takes to try and vindicate serious constitutional rights. And I do think while we do have two people who had some limited experience as a prosecutor, we don't have anyone who's got experience as a criminal defense lawyer. And that is, I think, a big gap. So while I'm glad that they've recognized that 95% of the cases are resolved by plea bargains, it's kind of smacking them in the face. But how much more they really have the sense of what it means, what the risk of improper convictions is, and what it would take to get one overturned in this day and age. I'm yet to be convinced that that's there.
What's missing on this court is also any experience that comes from running for public office. When Justice O'Connor stepped down, this became the first court in 2 centuries of American history with not a single member who'd ever run for public office. And whatever you think about, quote, politicians, unquote, you have to get out there and mix with people. This is a court that comes from very isolated and heavily academic backgrounds on both, whether we're appointed by Republicans or Democrats. So that I don't think there is almost a contempt for politics, a contempt for Congress that manifests itself. And I think we're on the possible brink of a major shift. There are attitudes on the court, I think, that would return to an area of state supremacy and limits on the federal government that we haven't seen since before the New Deal. Take, for example, the most striking question asked this whole term. When Justice Scalia at the immigration argument said to the Solicitor General, what does state sovereignty mean if it does not include the right to defend your borders? Well, that implies that New York could forbid New Jerseyites from coming into the state. One thing that we had was open borders within this country. The notion that, and the answer is, Justice Scalia, you and Justice Kennedy may think that states are sovereign, but they can't be in the full sense because they can't control their borders. That's not consistent with sovereignty, which means the states aren't sovereign in that sense. They can't coin money. They can't have an army, they can't have a navy, they can't engage in treaties, they can't make a compact with another quasi-sovereign without the express permission of Congress. Those are not attributes of an entity that has sovereignty, but the notion that a justice could think that controlling the borders of a state is an attribute of sovereignty that a state has fundamentally transforms, I think, the nature of our Constitution. You know, Al Kamen said that the founders gave almost all the powers to the states in their Constitution they drafted, and very little to the national government. And 11 years later, they found that didn't work. And they replaced the Articles of Confederation with the Constitution we actually have.
All right. Thank you all very much. I really appreciate it. Feel free to come up and ask questions to the panelists. Thanks to the panelists, and thanks to you all for being here.